In this video, we are going to discuss the structure of American courts. So, the American court system is one of those that is very confusing for people to understand oftentimes, and that's because we have a dual system. And what a dual system means is that we have a federal court system, and then we also have a state court system. And both of those have their own structure and processes for resolving disputes and prosecuting criminals. So one way of classifying the American courts is by the jurisdiction. And the jurisdiction is the legal authority and power of a court to hear a specific kind of case. So it could vary according to where the offense occurred, the seriousness of the offense, and whether the case is being heard for the first time or on an appeal. So for an example, the Supreme Court of North Carolina, they would not hear a case where a person received a ticket without it going through the previous courts first, because they do not have jurisdiction over that case at that time. So if you get a speeding ticket in Beaufort County, you would have to go to the Beaufort County Court rather than the Pitt County Court, because Beaufort County, again, has jurisdiction over your case. And we'll get over into the seriousness of the offense soon. So there's three types of jurisdiction. There's the subject matter jurisdiction, the geographical jurisdiction, and the hierarchical jurisdiction. So first, with the subject matter jurisdiction, the types of cases that a court is legally authorized to hear is usually misdemeanors and preliminary hearings, and their process are conducted by courts of limited jurisdiction. So I've put a map in here of the North Carolina court structure over on the left-hand side of the slide. If someone is, you have a person that burglarizes property, the dollar amount of the property that's stolen will determine where the case will be heard. So for example, if it is a misdemeanor, it would be less than $1,000 typically, so it would be heard in the district court. However, if someone steals $10,000 worth of property, then the superior court would have jurisdiction over it. So district court typically handles infractions and misdemeanors, and the superior court handles felonies and appeals from the district court. So geographical location or jurisdiction is determined by the political boundaries where the crime was committed. And again, I already said, if you break a law in Beaufort County, then you would go to the district court of Beaufort County or the superior court of Beaufort County. Then you've got your hierarchical jurisdiction, and it's basically the difference between the appellate and the trial courts. A lot of times students get confused about the word appellate. An appellate is simply the appeals courts. So the trial courts are the courts of fact, because that's the forum where a judge or a jury listens to the facts presented, and then they determine whether the defendant is guilty or not. And in contrast, appellate courts, they don't hear testimony or impose sentences. They just look to see if the law was applied correctly. So again, the North Carolina court structure. Let's say that I am convicted of a misdemeanor in district court, and I appeal that to the superior court. And then the superior court says, yes, you're still responsible for that. So then I can appeal it to the Court of Appeals of North Carolina, where they will look at my file. And then if they still say the law was applied correctly, so you're still responsible for this crime, I can appeal it up to the Supreme Court in hopes that they might hear it. So the court system in the United States can be divided into two separate entities, like I already discussed. You've got the state structure and the federal court structure, and that's why we're called a dual court system. And the court system at the federal level consists of the United States Supreme Court, which is typically referred to as the highest court, the court of last resort, then the U.S. Circuit Courts of Appeal, the U.S. District Courts, and the U.S. Magistrates. And the other court system is established through the authority of the states, and that is the example that I showed you a moment ago of the North Carolina court structure. So looking at both sets in the court organization, on the left-hand side of this screen, you've got the federal courts, and on the right side, you've got the state courts. And this is the hierarchy that they follow. So at each stage, it can move up to the next court, ultimately going over to the Supreme Court. Now, the Supreme Court has 8 justices and 1 Chief Justice. That makes up for a total of 9 justices sitting on the Supreme Court. They are appointed for a lifetime term. So once a person is nominated and approved to be on the Supreme Court, they typically get off the Supreme Court when they are deceased, unless they choose to end their term early. So again, the federal court structure has the authority to hear cases identified by the United States Constitution. Typically, if a state law is broken, it's going to be heard in a state court, whereas if it's a federal law, such as one involving a U.S. government official or one of the officers is being sued, it would go to the federal court system. Federal courts are also authorized to hear cases involving laws enacted by Congress. An example is a citizen from one state who sues a citizen from another state. That case may be heard in the state courts or in the federal district court. So the federal court structure consists of 4 basic levels: the Office of U.S. Magistrates, the U.S. District Courts, the U.S. Circuit Courts of Appeal, and then finally the United States Supreme Court. The lowest component is the United States Magistrate Court. It was created in 1968 to alleviate the workload of the district court judges, so they are a step below the district courts. And then in 1990, it was changed to magistrate judge. So a magistrate still has the same authority as a typical judge. Then you have your United States district courts. And at the federal level, there are courts of general jurisdiction. So most civil and criminal cases at the federal level are disposed of in United States district courts. And there are 94 district courts in the United States. The United States Courts of Appeal is the next step in the federal court structure, and it's often referred to as circuit courts. And they're basically intermediate appellate courts that they serve as a buffer between the district court and the Supreme Court to determine which cases need to continue on up the ladder to the Supreme Court. There are 13 courts of appeal. 12 of these appellate courts have jurisdiction over specific geographical areas. And the numbers of judges in each circuit court is determined by the sheer case volume. So areas that have large cases will have more judges. On rare occasions, a case may be heard en banc when the entire aggregate of judges in the circuit hears and decides the case appeal. This typically involves constitutional issues, and input from the larger number of judges is deemed important. So this is a map layout showing the boundaries of the district and appellate court. So if you were in North Carolina, you are in the 4th district. And lastly, the United States Supreme Court is the court of last resort at the federal level. Once the Supreme Court makes a ruling, there is no other alternative to go or another step above them. It ends with the Supreme Court. Also, interestingly enough, it's the only court that is specifically mentioned in Article 3, Section 1 of the Constitution. This court has original jurisdiction and exclusive jurisdiction over any and all actions or proceedings against ambassadors or public ministers of foreign states, as well as all controversies between 2 or more states. So meaning if North Carolina and Virginia need an issue resolved, it would go to the United States Supreme Court. This is one of the cases that you will be researching for your homework, so I'm not going to go into detail on it, but the Marbury versus Madison decision was one of those important ones that was decided back in 1803. So how does a case get to the Supreme Court? In order for a case to be placed on the docket, it must pass what is known as the Rule of 4, and that means 4 of the judges, and remember there's 9 justices on the Supreme Court, 4 of those must agree that they want to hear that case, or the Supreme Court won't put it on its docket. And its docket is the list of cases that it's going to hear. So the primary method that cases reach the court is through a petition known as a writ of certiorari, and it's an order issued by the lower court to send the record for review. So then you have the state court organization. And studying the American court system would be relatively easy if we didn't have the dual system, the federal and the states. And each state has their own different organizational structure. So then you've got 50 different court systems within the United States, plus the federal district or the federal court system. So the organization and functions of the 50 different states are diverse and complex because, again, each state can have their own court structure type. And generally, state courts have a 4-tiered court structure, and that's courts of limited jurisdiction, courts of general jurisdiction, intermediate courts of appeal, and courts of last resort. So the courts of limited jurisdiction have the greatest variability among the states, and these are what we would refer to as the district courts. They're the ones that hear minor offenses, such as violations of traffic laws, minor civil cases, and infractions. About 80% of the total number of state courts are courts of limited jurisdiction. The courts of limited jurisdiction are the courts with the highest case loads in the nation. So if you've ever had a speeding ticket and had to go to Beaufort County District Court on a traffic day, you know that it is typically packed with people that have received tickets. On average, they dispose of more than 50% of all the cases brought before the state courts. Then courts of general jurisdiction have jurisdiction over all major civil and criminal cases. So in North Carolina, if it is a felony case, the superior court would have jurisdiction, and that is a court of general jurisdiction. These are courts of record, meaning that a record is made of all of the proceedings that can be pulled up years later. In contrast to the district courts or limited jurisdiction, where the record is not. The Intermediate Court of Appeals, again, serves as a go-between between the district courts and the appeals courts. Not every state has these. And then the Court of Last Resort for a state is their state Supreme Court. North Carolina has a North Carolina State Supreme Court. And then lastly, the Courts of Last Resort in states with no Intermediate Court of Appeal, the state Supreme Court has no discretionary authority. Oklahoma and Texas are unique in that. Ohio is designated to hear civil cases, and the other hears only criminal cases.